All right, today we're diving into a system that sounds like it's straight out of a history book, but believe me, its ghost still haunts property law. We're talking about a world with no digital safety net, a world governed by unwritten rules and, yeah, actual physical stacks of paper. This is the world of unregistered title. So just picture this for a second. What if there was no central searchable database telling you who owns what? No government website you could just look up? How would you prove you own your home? More importantly, how could you ever feel safe buying one? This is the huge problem we're going to unpack today. So here's our game plan. We'll kick things off with the core problem. Then we'll meet the two kinds of claims on land. You've got the super powerful super rights, and then the spooky hidden ghosts. After that, we'll get ourselves a buyer's survival guide, put it all to the test in a case study, and then we'll see why these old rules still have a massive echo in our modern world. Okay, so in this world of unregistered land, you have to forget about digital records. Ownership isn't some neat entry in a government computer. Nope. It's a physical chain of documents. We're talking deeds, contracts, wills, stretching way back in time. Your proof of ownership is literally a stack of paper. And for a buyer, this whole system is a total minefield. Seriously, you can't just run a quick search online. You have to become a detective, piecing together this paper trail. And even then, there could be invisible claims on that property just waiting to jump out and bite you long after you've handed over the money. Okay, so to get through this minefield, we've got to start with the biggest, baddest claims out there. These are what we call legal rights, but you can just think of them as the super rights of the property world. They're the strongest claims of all. A legal interest is the heavyweight champion. It's officially created by a special, very formal document called a deed. And here's the kicker, the thing that makes it so incredibly powerful. It binds the entire world. It doesn't matter if a buyer knew about it, didn't know about it, should have known about it, doesn't matter. If that legal right exists, the buyer is stuck with it. End of story. So, what does this look like in the real world? Well, the two big ones you'll hear about are freehold. That's basically what we think of as absolute forever ownership, and leasehold, which is ownership for a fixed chunk of time. A proper formal mortgage or a right-of-way, as long as it's created by a deed, also falls into this super powerful category. Now, this is where things get interesting and a lot more complex. If legal rights are the solid walls and foundation of the house, then equitable rights, well, they're the ghosts hiding in the attic. These are the hidden claims, the ones that give buyers the biggest headaches. So an equitable interest usually pops up when the super strict legal formalities haven't been met, like maybe there's no deed, but an agreement still clearly exists. It's more flexible, but that also makes it more fragile. And just like a legal right, it binds the whole world. But there's one crucial exception. There is one specific person it cannot touch. And this, right here, is the absolute game changer. This is the key to understanding all of this. A legal right, it binds everybody. No ifs, ands, or buts, but an equitable right, it gets defeated by this very specific person, a bona fide purchaser of a legal estate for value without notice. Now that's a mouthful, but what it really means is an innocent buyer, someone who's acting in good faith, pays for the property, and has no idea about this hidden right. Okay, so if you're that buyer, how on earth do you protect yourself? How do you make sure you're that innocent person who can defeat these ghosts? Well, don't worry, there's a survival guide for navigating all these traps. Luckily, the law helps us out here. It splits these equitable ghosts into three main categories, and each one has its own special defense. First, you've got your commercial rights. These are businessy things, like a contract to buy the land. Your defense? You search something called the Land Charges Register. Second, there are family or trust rights. This is like a partner's financial share in the house. The defense is a really clever process called overreaching. And finally, you have the residual rights, basically all the leftovers. For these, your only defense is something called the doctrine of notice. Let's zoom in on that second one, because the way you deal with family rights is honestly kind of brilliant. It's a process called overreaching, and it's designed to be fair to everyone. Here's how it works. The buyer pays the purchase money to at least two trustees, not just the one seller. When that happens, the family member's right magically lifts off the land itself and reattaches to the money that was paid. They get their financial share, and the buyer gets the property, clean and clear. So what's the magic number here? It's 2. That's it. 2. You have to remember that. Paying just one trustee is not good enough. The law demands two as a safeguard to make it much, much harder for one person to just take the money and run, leaving the family member with nothing.
All right, so what about those leftover rights, the ones that don't fit anywhere else? For those, a buyer is only safe if they are without notice. And notice comes in three flavors. First is actual notice, stuff you literally knew. Second is imputed notice, stuff your agent, like your lawyer, knew. And the trickiest one is constructive notice. This is the stuff you should have known if you'd just done the reasonable inspections a normal buyer would do.
And look, this isn't just some vague idea. It's spelled out right there in the law. The statute basically says you're on the hook for anything that you reasonably should have found out. So did you actually visit the property? Did you look around? Did you see signs that someone else was living there? Did you ask the obvious questions? Because if you didn't, you can't later turn around and claim to be a totally innocent buyer. Okay, enough theory. Let's get our hands dirty and put this whole survival guide to the test with a classic scenario involving a property called Whiteacre. Here's the setup. We've got John, he's the seller, and we have Frank, our poor, unsuspecting buyer. Then there's a whole cast of other people. Mark, who has a lease, Debbie, a neighbor with a right-of-way, Tim, who has a written agreement to buy the place, and Beth, John's partner, who helped pay for the house but is currently backpacking. The big question is, when Frank buys the house, whose rights are going to survive?
All right, let's break it down. First up, Mark, the tenant. His 8-year lease was made by a deed. Ding, ding, ding. That makes it a legal right, a super right. It binds the whole world, which means it definitely binds Frank. So Mark gets to stay. Now, Debbie, the neighbor, her right-of-way is an equitable easement, which falls into that commercial rights category. To protect it, she had to register it as a land charge. If she didn't, sorry, Debbie, her right is totally void against Frank. Tim, the other potential buyer, is in the exact same boat as Debbie. His agreement to buy is an estate contract, another commercial right. His only move was to register it as a land charge. If he didn't, his contract is worthless against Frank. And finally, Beth. She has a family right. Frank only paid one trustee, John, so her right was not overreached. That means everything, and I mean everything, comes down to that final test, the doctrine of notice. Was there any sign of Beth at the house? Clothes, mail, anything at all that a reasonable inspection would have picked up on? Her entire claim hangs on that one simple question. So after all that, after navigating this super complicated, kind of ancient world, you might be sitting there thinking, okay, but why does any of this actually matter today? Isn't pretty much all land registered now? And that's a fair question. It matters for a couple of really big reasons. First, seeing how messy this all was really makes you appreciate the genius of our modern system where everything is just in one place. But maybe more importantly, it shows how the law came up with these incredibly clever tools like overreaching and notice to strike a delicate balance between protecting an innocent buyer and protecting people who have a real legitimate stake in a home. So I'll leave you with this to chew on. For hundreds of years, our most valuable physical asset, land, was governed by these invisible rules and this duty to make reasonable inspections. Now, think about our lives today. What are the invisible rules and assumptions that govern our digital property, our data, our online identities? And what reasonable inspections should we be making in that world? Thanks for watching.